Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning. It is Saturday, June 24th, 2023. My name is Jim Santel, and this is our weekly review, our analysis and our discussion of those most important news stories and events in the areas of law and government and the aspiration for justice in America. Thank you for joining me again this beautiful Saturday morning. We're coming to you from the studios of WAUK Radio in downtown Waukesha, but broadcasting throughout the listening regions of civic media throughout this wonderful state of Wisconsin. We're also taking your calls this morning, both this hour and in our second hour. That phone number is 844-967-2789, 844-967-2789, always in partnership with my professional, engaging, and wonderful producer Anya, who's with me in the studios this morning. Looking forward to hearing your calls, your questions, your comments, your observations about the topics of our days. And as always, this morning, coming live to you from Waukesha, going out throughout the state of Wisconsin, we have an ambitious, always ambitious, but achievable syllabus and agenda for you this morning. Hopefully educational and also even inspiring. Always asking those three important questions. What happened? What do we know? What are the facts of the events, the circumstances that animate our lives? Why are those things important? Why are they significant to us? Why are they relevant and material? And what, if anything, can we do, should we do, as Americans responsible for the future of our nation and our world? What are the appropriate responses, reactions, and actions in response to the news? Why it is important and our actions in response to all of that. Today, spending principal focus on the United States Supreme Court, as we have done in previous broadcasts. This is the time of year, every year, June of every single year, when our United States Supreme Court, the highest court in our land, issues major decisions of significant importance to all of us. No exception with respect to those decisions already rendered, already given to us by the 9 justices up to this point in our history of this year. Also anticipating that next week, Tuesday and Thursday, likely to be the most significant decision days in this term of the United States Supreme Court, 2022, 2023. We'll talk about some of the cases likely to be issued, decisions, rulings likely to be given out next week on those days, and certainly be spending a lot of time in our next program on the 1st of July, talking about those important cases, those to be decided this coming week. But this week, this morning, in this principal hour, and perhaps in the next hour as well, we're going to talk about at least 4 of the major cases that have been decided by our Supreme Court, even since we have been together live here on the studios, the broadcast studios and broadcast areas of civic media. We're going to chat about why those cases are important in their individual facts, but also consistent with our commission to talk about why these things are relevant and important, why those cases, these 4 in particular, have great meaning beyond just the particular rulings for our future and for the livelihood of all of us here in the United States of America. We're going to be chatting about all of those 4. As a way of introducing that, of course, we could not chat today about our United States Supreme Court without observing the fact that today is the 1-year anniversary of the rendition, the issuance by our United States Supreme Court of one of the most landmark, significant cases in all of its history. And that, of course, is the case of Dobbs, that overturned Roe versus Wade, reversing nearly 50 years of an understanding that inside our Constitution, there is built in, by virtue of something called a penumbra of rights emanating from all sorts of areas inside our Constitution, a fundamental right to privacy, and in particular with respect to Dobbs versus Jackson Reproductive Services, particularly in that case finding that the long-standing 49-year tradition, 49-year precedent in our nation establishing a right to abortion in our states, in all 50 states, no longer adheres in the Constitution. decision and sending that decision back into the states for its determination, for the determination of legislatures and courts throughout the United States of America. That happened. That happened 1 year ago today. A decision, not a unanimous decision by any means, strong dissents on behalf of the minority population of our Supreme Court, but an equally strong statement by our United States Supreme Court, written by Justice Samuel Alito. We're going to hear more from him in just a moment or so as well. A decision that told us that Roe versus Wade is not only antiquated, but simply wrong at the time of its decision. And that Justice Blackmun, when he issued that decision way back in 1973, January of 1973, was simply mistaken and was misleading us, was telling us something that wasn't true about our Constitution at the time that he rendered that decision. We know that in the wake of the 1973 decision, in the wake of Roe versus Wade, abortions were proper, were legal, at least in the first trimester, and a case following up on that called Casey, authored by Sandra Day O'Connor, sort of the strict trimester approach articulated by the Supreme Court in Roe versus Wade was abandoned in favor of a broader standard that talked about viability of the fetus. But we know that at least in the first weeks of a pregnancy, for 50 years, the states had no right to intervene. Greater involvement of the states during approximately the second trimester, and there could in fact be state intrusions, state restrictions on abortion in that final trimester. We also know, of course, that in America in those 50 years, the great majority of abortions took place not in that final trimester, but rather in the first trimester. And that's why this change in the law accomplished a year ago today was so dramatically significant in the history of our lives for all women and all men, I would also offer, in the United States of America. Not only did it change the landscape of our understanding of abortion rights in America, and we'll talk more about what has happened in the years since that issuance of the decision, but also opened the door to question whether or not there's a fundamental privacy right inside the Constitution itself. Privacy rights going back to 1965, probably even before then, but articulated by the Supreme Court in a case called Griswold versus Connecticut, finding a clear privacy right emanating from the Constitution, this penumbra notion that I described before, emanating from various rights, the Ninth Amendment, fundamental rights throughout the United States Constitution that establish privacy rights for all of us. And those things include things like the right to make decisions about medical care, end-of-life treatment, what your family looks like, same-sex marriage, interracial marriage, all kinds of things out there. A list is long. And the concern about the rescission of Roe versus Wade by Dobbs is not only with respect to the dramatic impact that it had upon abortion rights in America, but also this notion that for the first time in our history, it turned back the movement forward, providing more privacy rights for all of us in America. And of course, we've got at least one justice, Justice Thomas, who has said that effort to turn back privacy rights in America should continue. And so it opens up the door, great significance for that decision issued a year ago today. What has happened since the past year? Well, we know that because of this decision, finding that the Constitution no longer protects under privacy rights theories the right of women to an abortion, to reproductive services. We know that there are at least 14 states that have, through legislative fiat, other movements, banned abortions entirely. Probably another 12, depending upon how you count their restrictions, their limitations, that are either heading in that direction or somewhere in between. We've got about 26 states, about half the states in our union this day, a year after the rendition of the decision in Dobbs, that have imposed precisely the restrictions that were described if, in fact, Roe was overturned. There are about 20 additional states, to the credit of them, that have enhanced and supported and even adopted new measures to ensure abortion rights. But we've got a struggle out there, both legislatively and also in the courts right here in the state of Wisconsin. We've got litigation determining whether or not 1840 1849 legislation that banned abortion made it criminal in our state, whether that's still viable, or whether subsequent pieces of legislation overtook that, overturned that, effectively rescinded that, or if indeed the mere passage of time since 1849 means that we should no longer be observing that 1849 statute. That goes on right here in the state of Wisconsin. We know as well, recent polling indicates that about 6 in 10 Americans, 60% of us, support in some way, shape, or form abortion rights, privacy rights, reproductive rights under our Constitution. We know as well that in the past year, we have had some troubling developments in a number of different areas, rises in violence against those people who legitimately, lawfully, in many states continue to provide abortion services, a 231% increase in stalking, a 100% increase in arson, a 229% increase in burglaries, even home invasions, property invasions, a 25% of that. Clinics and other places of medical health providing being closed or shut down, confusion about the shifting laws in various states. 66 clinics have either stopped providing abortion. Among those, about 26 shut down entirely. There's been a rise in telehealth abortion. And of course, we also know that this issue related to mifepristone, right now pending in front of the Fifth Circuit Court of Appeals, still not resolved, about whether or not the authorization given mifepristone, which is this all-important drug that accomplishes abortions medically, safely, according to the FDA, also addresses other healthcare matters in connection with pregnancies and miscarriages in particular, whether that drug will be commonly available throughout the United States of America. That continues to be unresolved, sitting right now in the Fifth Circuit Court of Appeals. And even to this day, legislatively, there is more movement in the wake of the decision, the vacation of Roe versus Wade. Lindsey Graham and other senators announcing that they are going to be pushing for a nationwide ban in all of our states of abortion through the United States Congress. He, of course, the United States Senator. All of that happening in the wake of the determination that privacy rights no longer include the right to abortion in America under our Constitution, under the ruling of the United States Supreme Court. Today, the anniversary of that announcement. When we come back after this first break, we're going to chat about other cases decided recently by our United States Supreme Court in a number of also hugely important areas. Stay with us for that discussion and more this morning on Morning Cannolis.
This summer, 5:40 a.m. WAUK has a new lineup. At 12:15, Wisconsin Roundtable. 1 to 3, The Todd Alba Show on 5:40 a.m. WAUK. WAUK has a new lineup. At 12:15, Wisconsin Roundtable. 1 to 3, The Todd Alba Show on 5:40 a.m. WAUK. WAUK has a new lineup. At 12:15, Wisconsin Roundtable. 1 to 3, The...
A Fiddler on the Roof. Sounds crazy, no? But in our little village of
And
Anakevka,
we are
you
back
might
this
say
morning on
every
Morning
one of us
Cannolis. We're
was a fiddler
celebrating
on the
this
roof.
morning also Broadway and Broadway musicals in particular, observing today the recent death of one of the major figures in Broadway history who authored the lyrics to that important piece of music. 99 years old at the time of his death, a significant death in the history of America. His name in particular, Sheldon Harnick. He was born in Chicago 99 years ago. He died this past week. The author of lyrics in the Broadway musical Fiddler on the Roof, other musicals, including She Loves Me. Celebrating today all kinds of Broadway musicals being brought to you through the wonderful music selections of my terrific producer here this morning, Anya. And again, thanking you for joining us this morning on Morning Cannolis. I promised right before the break that we're going to be chatting about the United States Supreme Court this morning, and indeed we're going to do that all this hour and probably some of next as well. And yes, indeed, we are going to talk more about ethics related to the conduct of our Supreme Court justices, brought once again to the attention of America and certainly the attention of at least a couple of United States senators by virtue of the revelations related to the past conduct of Associate Justice Samuel Alito in a fishing trip that he took many, many years ago to Alaska. We'll talk about that, the consequences of that, why that's relevant, and why that's meaningful as well. This morning, in our next segments, talking about 4 major cases that have been issued by our United States Supreme Court in its final tranche, if you will, its final period of time during which it's going to be issuing a number of different cases. Let's talk about all of those, not only discussing what those cases mean, but also why they're important beyond just decisions being made. Let's begin with a decision rendered just yesterday, just Friday, that basically said that the Biden administration could, in fact, set priorities for which undocumented immigrants to arrest and which to leave alone, very broadly speaking, basically rejecting a challenge from 2 very conservative states that had pressed for some more aggressive enforcement and basically handing a huge victory to the Secretary of Homeland Security and President Biden more generally. Where does this come about? How does this case develop, and what is the history behind all of this? We recall well that during the Trump administration, there was this pledge basically to take the shackles, as the Trump administration authorities said, off of Immigration and Customs Enforcement, ICE agents, and basically saying that anyone in the country without legal documentation could be targeted for deportation. That was basically the approach of the Trump administration. Under those guidelines, the agents, again, under the supervision of the Secretary of Homeland Security, had broad breadth, if you will, to address not only those who pose the most significant threats to our community, but also people who are here, admittedly illegally, but who are not causing any problem, not committing crimes. And when the Biden administration came in, they basically said, we're not going to pursue that anymore. We're going to recognize a couple of things. We're going to recognize first that we have limited resources. We know well that the Congress has not addressed the issue of immigration, both in terms of staffing, but also in terms of policy for many, many years. And one of those issues is that resources have been depressed for a long period of time. And so as a result of that, the question has been, with limited resources, where do you allocate those resources most effectively for purposes of understanding, for promoting our immigration purposes? And the Biden administration said, we're going to reject the guidelines set forth by the Trump administration, and we're going to focus only on those who have the most significant national security threats, who pose the greatest threat to our safety, our security, engaging in crime and those kinds of activities. And so the Biden administration announced these new guidelines, these new principles, well over a year or so ago, basically giving the Secretary of Homeland Security the authority to say that under limited resources situations, we're going to have our agents identify and deport those people at the top of the list who are posing the greatest security risk and prioritizing those as opposed to going after those people, again, illegally here, but nonetheless not providing a reason for believing they're engaging in crime or other national security threats. Are basically a reasonable recognition, a law enforcement recognition, given limited resources, of where you best apply and address the problems of immigration. Well, what happened, as I said, we've got a couple of states, Texas and Louisiana, that said, wait a minute, that is not proper. We are going to allege that that kind of change in the policy is illegal, and they did so. And they brought this lawsuit challenging that in particular. Makes its way ultimately to a federal district court judge. His name is Drew Tipton. And for about a year, because Drew Tipton found that those new regulations of the Biden administration were in fact illegal, were an exercise of executive authority that could not stand, he basically suspended those rules and regulations, telling the Secretary of Homeland Security that, nope, you cannot do this. You cannot make that kind of legitimate, sensible, resource-based, legally based, law enforcement based decision about how to apply the immigration laws. Fairly outrageous thing for a federal district court judge to do. And that stayed in place until just yesterday, when the United States Supreme Court got a hold of this and said, wait a minute. This lawsuit should not be here at all in the first place. Interestingly written by Justice Brett Kavanaugh, and again, giving a major victory to the Biden administration when it comes to the enforcement of laws. Brett Kavanaugh is saying in particular that if this court greenlighted this lawsuit, we could anticipate complaints in future years about alleged executive branch under enforcement of any similarly worded laws, whether they be drug laws, gun laws, obstruction of justice laws, or the like. We declined to start the federal judiciary down that uncharted path. And so he basically said, no standing, no basis in these states to challenge this. We're not going to do this. The Biden guidelines stand. When we come back, I'm going to give you more insight into exactly what Brett Kavanaugh was talking about, and then also talk about the dissents coming from some anticipated justices, and explaining once again why this case is important not only for immigration, but beyond that, for the enforcement of law in America, right here on our broadcast. Stay with us for that.
Preparing me to marry whoever Papa picks. The daughter. Succeed, follow my lead, and yes, indeed.
And we are back this morning on Morning Cannolis. We're talking in this segment and next segments all about our United States Supreme Court in this time of year when indeed they're issuing these major decisions affecting our lives. First one we're chatting about this morning is this case involving immigration, something that the legislature itself has not addressed. Our Congress has not addressed for a long period of time, but the Supreme Court did just yesterday, handing the Biden administration a major victory when it comes to its authority, its discretion in making law enforcement decisions about how to enforce our immigration laws. A huge victory for the Secretary of Homeland Security and making the decision, the appropriate decision to apply limited resources to address those folks who are here illegally, but who also are engaging in criminal activity, posing a threat to our national and local and statewide safety and security, even national security, focusing on that as opposed to other folks who are here illegally, but who are not posing those same threats. Along the way, significantly, Brett Kavanaugh, writing for the majority, comments once again about the capacity of these states to bring this lawsuit. In particular, he says, the states have brought an extraordinarily unusual lawsuit. That's peculiar commentary for a Supreme Court justice to describe a lawsuit in that way. He says they want a federal court to order the executive branch to alter its arrest policies so as to make more arrests. Federal courts, he said, have not traditionally entertained that kind of lawsuit. Indeed, the states, those bringing this challenge to the Biden administration rules and regulations, the states cite no precedent for a lawsuit like this. He said that if Congress was free to act if it was dissatisfied with the Biden administration's approach, but he went on to say Congress possesses an array of tools to analyze and influence those policies, and indeed they do. They can do some oversight, they can do appropriations, the legislative process itself, Senate confirmations, all those kinds of things that Congress can do. However, you don't do this through the federal courts, Justice Kavanaugh, and indeed 7 other members of the Supreme Court agreed with him. This was an 8-1 decision yesterday. Only Sam Alito in the dissenting position. He said that the majority had given much too much leeway to the executive branch. He said, to put the point simply, Congress enacted a law that requires the apprehension and detention of certain illegal immigrants whose release, it thought, would endanger public safety. The Secretary of DHS, Homeland Security, does not agree with that categorical requirement. He prefers a more flexible policy. Well, that may in fact be true, Mr. Associate Justice, but he again in the minority, thankfully, yesterday. A major case, not only for immigration enforcement here in the United States of America, but why is it significant beyond just that? 2 reasons I'd offer. One is, of course, we all still have a great deal of work to do in this area of immigration. The Deferred Action for Childhood Arrivals, or DACA program, established under the Obama administration, that continues to be the focus of both legislative review and certainly judicial review. Curious to determine whether or not the United States courts, the United States officials generally, will regard this case, again involving Joseph Biden and the states, Texas, Louisiana, and others out there, if they regard this language as something to be taken a look at and be guiding their own responses to our DACA challenges accordingly. Immigration laws generally today, again, need to be addressed to bring them current, not only in terms of resources, which the majority identified just yesterday as a major problem in our nation, but beyond that, this lawsuit and the decision in particular makes clear that the federal courts should not be involved in what are called these policy-related decisions, right? When finding that Drew Tipton, this federal district court judge in Texas, had overstepped his bounds, basically saying you have no business playing in this area in the first place. This is not only, as he said, wildly unusual, but no jurisdiction, no standing for these particular states to bring this into court, no basis, no damage, no harm to them. What is this case doing here? Hopefully sending the message to others who would attack these kinds of discretionary decisions, frankly, made by all administrations, regardless of which side of the political aisle they happen to fall. Those are things properly vested in the executive branch. Once the Congress gives the authority to a secretary, including the Secretary of Homeland Security, to act, that's the kind of thing that should be given broad breadth in terms of discretion allocated to that secretary and others in other areas of executive authority. So again, a major case not only for immigration, but hopefully a lesson taught to all of us out there in all areas about the proper roles of the executive branch and the legislative branch, and yes, indeed, the judicial branch as well. Major case, Texas versus Biden, United States versus Texas, depending upon how you codify and describe the case, coming out just yesterday from our United States Supreme Court, going to define a lot of our future. Let's talk about another one of those cases decided a couple of weeks ago, also defining our future, also to the good. Another reason to celebrate in the midst of some other concerns about what the Supreme Court has done historically, to celebrate a couple of its recent decisions. This case is called Allen versus Milligan. We have talked about this case at length in the past. This has to do with gerrymandering and the access to polls. Voting rights in America, the Voting Rights Act passed in the 1960s as a way of ensuring that people of all races, of all colors, have access to the polls. Originally acted in 1965, Section 2 of that act, which is this basic enforcement principle under the act, tracks the language pretty much of the 15th Amendment. What does the 15th Amendment say? Provides that the right of citizens of the United States to vote shall not be denied or abridged on account of race, color, or previous condition of servitude. One of those major post-Civil War amendments to our Constitution. 1965 Voting Rights Act, that's what it says. Other sections, Sections 4 and Section 5, which we'll touch upon in just a few moments, also provide enforcements of the 15th Amendment and the Voting Rights Act in particular. What happens? Well, how do we get back to the United States Supreme Court in this case called Allen versus Milligan, decided on June 8th of this year, June 8th, just a couple of weeks ago? Well, way back in 2021, the Alabama legislature, and yes, that's where this case comes from, Alabama, just like here in Wisconsin, drew some legislative lines, new congressional maps that undisputably gave black voters in Alabama far less representation in the House of Representatives than their population numbers would generally indicate. Now, what do I mean by that? Well, it's very clear. Nobody disputes this, that African Americans in the state of Alabama compose about 28% of the state's total citizenry. This total population, about 28%. The state of Alabama has 7 congressional districts allocated to it by virtue of the census and by virtue of those allocations generally made throughout the United States of America. And so, very generally, as we have discussed here in Wisconsin, what are the appropriate allocations to be made? What kinds of things should we be concerned about when it comes to racial gerrymandering? Well, very generally, that 28% would mean that roughly 2 of those 7 districts would be districts that would be principally black majority in nature, where the prospects of there being elected a black representative to the United States Congress would be enhanced, increased, not necessarily guaranteed, guaranteed, but there would be black majorities who could vote in favor of those candidates that they feel most strongly, appropriately represent their interests in the Congress. So the United States Court of Appeals for the Fifth Circuit, a 3-judge panel, a number of years ago, gets a hold of this. And basically, the Alabama legislature, once again, does not, in fact, draw those lines, gives one of the 7 districts to black majority populations. The United States Court of Appeals says no. You did that improperly, and the Voting Rights Act requires you to do a better job, says to the Alabama legislature, go back and do this again. You've done it improperly. Go back and redraw some lines here in such a way that probably 2 of the 7, not just 1 of the 7 districts, do in fact represent blacks more equitably. And it turns out that under a case called Thornburg versus Jingles, many, many years ago, Thornburg versus Jingles, in that case, the Supreme Court established the standards under which federal courts address these kinds of things. And there are many standards, basically analyzing the demographics, the nuts and bolts, we would kind of say the science of voting, getting involved in the weeds, what's going on in Alabama, what's going on in Wisconsin, other states, doing an analysis based upon who lives where, what the population is like, how it votes, the historical basis of discrimination, those kinds of things. Thornburg versus Jingles establishes these standards, including 2 in particular. Whether you could draw a second in Alabama, a second majority black district. And in fact, turns out you can, without doing great discomfort to line drawing. Turns out that much of the, not all, but much of the black population in Alabama is in and around Atlanta and other places as well. And you could, in fact, draw 2 districts without being gerrymandered or salamandered, as that word originally comes from, in such a way that you would look and say, gosh, that district looks very odd to me just geographically. You can do that. You can draw a second majority black district because African Americans live in those areas sufficiently close in proximity to do that. And second, you need to show that Alabamans generally vote as a bloc for candidates who are generally opposed by voters of color. And again, that's perhaps a difficult thing to say out loud, but that's part of the standard under Thornburg versus Jingles, one of the many standards that are brought to this analysis of whether or not there's been gerrymandering. And so the Fifth Circuit looks at Thornburg versus Jingles and says, yes, Alabama, you have violated the Voting Rights Act under Thornburg. Go back and do it again. The Alabama legislature, not happy with that, says, number one, no, we did not, in fact, do any gerrymandering at all. What we did is we drew lines appropriately, no violation of the Voting Rights Act. The 1 district that we provided, which was majority black, that comports with the law. And second, and this is why this case is so very important, the legislature also came back and said, abandon Thornburg versus Jingles, abandon that kind of testing analysis that determines whether or not gerrymandering is in violation of our Constitution, of our fundamental rights to ensure that all Americans have access to the polling places. And effectively asking the Supreme Court to withdraw that standard and apply a second standard, a new standard that would establish that all you need to do is come forward with one legitimate, non-racial basis for going ahead with changing lines in a congressional district. Even if the impact is to have a discriminatory effect on voters, all you need to do is come forward and come up with one justification. That would be enough. And an awful lot of people, including me, as we've talked on this broadcast in the past, looked at this case, again, Allen versus Milligan, and thought, gosh, the Supreme Court may well be on the verge of dealing another blow to the Voting Rights Act. And we waited with bated breath to determine what the Supreme Court would do. In fact, it did not do that. It did not send another blow into the Voting Rights Act. In fact, earlier this month, by a 5-4 vote, the court effectively reaffirmed the standard in Thornburg versus Jingles and concluded that Alabama had in fact diluted the power of black voters by drawing a congressional voting map with this single district in which the voters of color comprise the majority. So basically saying that the legislature, you're completely wrong. You got to go back and draw lines better than you have. You got to establish that second majority black district. A major case under the Voting Rights Act, again, reaffirming this standard under the 1965 law. Along the way, Chief Justice John Roberts, joined by Associate Justices Brett Kavanaugh, once again, Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson. That's the five. They say this: we have applied the Voting Rights Act in an unbroken line of decisions stretching 4 decades now. For 40 years, we've done this. The court, that is, the court as of this month, sees no reason to disturb what it described as the lower court's careful analysis that Alabama's extensive history of repugnant racial and voting-related discrimination is undeniable and well documented. Basically describe this repugnant racial and voting-related discrimination in the state of Alabama and sending that packing. That is strong language for a United States Supreme Court to tell an Alabama or any legislature what it has been doing. Associate Justice Clarence Thomas, joined by Alito and Amy Coney Barrett and Neil Gorsuch in dissent, say basically that the majority forces Alabama to intentionally redraw its long-standing congressional districts so that black voters can control a number of seats roughly proportional to the black share of the state's population. That's correct. That's right. That's exactly what they do. They go on to say Section 2 demands no such thing, and the Constitution would not permit it. They're in the minority. They're the four in the minority. Their view does not stand. It is not the basis for the decision in this case, again, coming out of Alabama, coming out of a United States Supreme Court. Right after the break, we're going to talk about why this case, again, hugely important for voting rights in America and beyond. Stay with us for that important discussion.
You'll be popular, just not quite as popular as me.
We are back here in this final segment of our first hour this morning on Morning Cannolis. We're talking all about the United States Supreme Court. A couple of cases already under our belt related to voting rights here, discussing this case coming out of Alabama. The reason why it's very significant, the Supreme Court, in a break from its recent history, would support the Voting Rights Act, a reason to celebrate in America that the Voting Rights Act, at least with respect to Section 2, remains strong in the standards under which we assess gerrymandering attempts by legislatures and others around the country. That remains strong, according to not only the so-called liberals on the court, but also the Chief Justice, John Roberts. And yes, indeed, Brett Kavanaugh once again joins with the majority in finding that the Voting Rights Act does in fact have meaning today. Why is that significant? Well, again, in recent years, the United States Supreme Court has dealt some significant blows to the Voting Rights Act. A case called Shelby County versus Holder, finding that a combination of what are called Sections 4 and 5 of the Voting Rights Act, those sections together provided, again, ever since 1965, that in those districts that had historical records of engaging in discriminatory conduct, before they changed their laws with related to voting, they had to get permission. They had to get permission by the United States Department of Justice, the Voting Rights Section, before that happened. That was part of the legislation. Basically, the United States Supreme Court, in a case written by Chief Justice John Roberts way back in a number of years ago, said that those kinds of standards are no longer applicable, that America, if you will, almost lives in a post-racial nation. Certainly stunning to say that. But beyond that, that Sections 4 and 5 no longer have the restrictions that they have had in the past. And that's what opened up all of these opportunities for legislatures, including Alabama, other places around the country, to impose new restrictions not seen in decades upon people of color seeking to vote in America. Shelby County versus Holder, that case. And then more recently, a case a couple of years ago, Brnovich versus DNC, coming out of Arizona, another case, finding that Section 2, when it comes to allegations of fraud and basically the limitations of voting aspects, that trying to limit voting opportunities, that those things can in fact be upheld. Again, a couple of particular statutes passed by the Arizona legislature, upheld by the Supreme Court, and viewed as limitations on the capacity of the Department of Justice and others to enforce the Voting Rights Act. That's the history of our recent Supreme Court, and that's why this decision just this month, supporting the voting rights for the first time in many years, is very significant. There is yet another voting case case that's still pending in front of the United States Supreme Court called Moore versus Harper. Has to do with this crazy thing called the independent state legislature theory. We'll talk about it down the road. It's still pending there. It may well be coming out of North Carolina. The Supreme Court will not have to decide that case for a number of procedural reasons, but it's still out there. So we've got at least one more case the Supreme Court is going to be addressing when it comes to voting rights in this term. But we know now that at least with respect to 5 of our justices, a strong affirmation and an affirmation that the law means something, that the Voting Rights Act does apply as we have understood it generally to apply, and that is a more restrictive standard when it comes to assessing gerrymandering does not indeed apply. Case, again, very important in the history of our nation just this month. Let's talk about yet a third case this morning, also coming out of our Supreme Court. Just about 10 days or so ago, Supreme Court has upheld a 1978 law, aimed at keeping Native American adoptees and other children who are subject to children's court, sometimes family court, with their tribes and with their traditions. It hands a victory, undeniably a victory to tribes that had argued that a blow to the law would upend the basic principles that allowed them to govern themselves for many, many years. This case, again, pitted a white foster couple from Texas against 5 Native American tribes and the Interior Department, and they were all battling over the adoption of a Native American child. Now, under something called the Indian Child Welfare Act, called ICWA, sometimes referred to as ICWA, the ICWA, the law required that when it comes to issues related to adoptions and placements and those kinds of things that Children's Court in particular addresses on a regular basis, those kinds of things that are before our state courts and indeed state courts right here in Wisconsin, that the Indian Child Welfare Act affecting these custody, foster care, adoption matters. And it's a complex law. And basically it provides that if a state court determines that a child before it is either a member of an Indian tribe or is eligible for that membership in a tribe, is a biological child of a member, and for that reason should be placed with an American Indian family if possible. So the law is quite clear on its import. There are some good cause exceptions to it. Plainly does not erase the discretion of particular judges to make determinations based upon the facts, but there is this very strong presumption. And it is based upon, as we all know, hundreds of years of history in which we have variously decided and determined to try to erase Native American heritage from among young people and middle-aged people and even old people of Native American heritage and history. Our history in this area has not been a happy one, has not been a good one. Not only the Trail of Tears, which we all know well, but also changing legislative enactments that variously contemplated assimilation of our Native American indigenous populations and then turned back and said, no, let's embrace Native American history. And that has gone back and forth for many, many years. Again, in 1978, the Congress basically says, no, we should indeed be ensuring that Native American children in particular have a connection to their heritage and have some way of determining as they grow old and as they grow up what their heritage is all about. And so this action brought by this couple seeking to adopt a Native American child challenged the constitutionality of ICWA, the Indian Child Welfare Act, challenging it, saying, no, indeed, it accomplishes an equal protection violation. It may also accomplish some racial discrimination packed into that equal protection argument. Supreme Court addresses all of this, and indeed, by a vote of 7-2, the justices uphold the legitimacy, the legality, the constitutionality of ICWA, the Indian Child Welfare Act. Amy Coney Barrett, writing for the majority, affirms the power of the Congress to make laws about Native American tribes, and in particular child welfare. The ruling significantly did not resolve this question of whether the law, the Indian Child Welfare Act, discriminates against non-Native families based upon race. That so-called equal protection argument is still out there. But again, a major victory for not only the tribes, but for all Americans when it comes to ensuring that heritage is important, and heritage is regarded as an important aspect of dispositions in our courts. When we come back and start our second hour, I'm going to talk more about this ICWA challenge, the decision issued just early this month by the Supreme Court, and yet more Supreme Court decisions this term right here on Morning Cannolis. Stay with us for that discussion.
Seasons of love. Seasons of
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
This is our second hour here on Saturday, June 24th, 2023. Thank you for once again joining me in our discussion this morning about all things Supreme Court related. This is indeed the season, June of every year, when the Supreme Court issues some, if not all, of its major decisions, and the Supreme Court is not disappointing this time around. In our first hour, we not only observed that today is the one-year anniversary of the landmark decision in Dobbs versus Jackson Reproductive Services, changing forever the landscape of abortion services and arguably privacy rights more generally in America. 1 year ago today, a decision issued by the United States Supreme Court. We not only did that, but we also began our discussion about recent cases decided by our United States Supreme Court. Spent a fair amount of time talking about this case, Texas versus Biden, that affirmed the capacity, the discretion of the Secretary of Homeland Security to make law enforcement decisions according to his or her good law enforcement-based judgment, and in particular, permitting the Secretary to address those people who are illegally here, who pose the greatest threat and to the security and the lifeblood of our nation. That decision by the United States Supreme Court affirming that executive authority, very significant for immigration enforcement. Before the break, we're also chatting about this other case involving voting rights in America. In Section 2, another reason to be pleased with our Supreme Court these days, a case called Allen versus Milligan, affirming the Voting Rights Act, affirming the notion that there is gerrymandering in America, including in Alabama, and it needs to be addressed when indeed gerrymandering for the purpose of racial discrimination is accomplished by a legislature. That case sent back to the Alabama Supreme Court to do their line drawing over when it comes to congressional districts, an affirmation of the Voting Rights Act and access by people of color, people of all indigenous backgrounds, immutable characteristics in America, to the polls in our nation. And right before the break, we're also then talking about this case called Haaland, Haaland versus Brackeen, Brackeen. This case has to do with Native American children and this law, called ICWA, that basically establishes that when it comes to decisions made by courts, state courts addressing things like adoption and foster care and placement of young people, the court should take into account whether or not a child is indeed of Native American heritage, a member of an Indian tribe, eligible for membership, biological child of a member, and if in fact that finding is made, should be placed with an American Indian family. Why? To preserve the heritage, the history of the family, and in particular of our Native American populations, indigenous populations here in the United States of America. Some good cause exceptions to that, not robbing state courts of complete jurisdiction to do justice, but affirming that fundamental notion that heritage means something in our nation, especially when it comes to our indigenous populations, our Native American children. And so a challenge to that law, which again has been in place since 1978, and by a 7-2 majority, the United States Supreme Court affirming the legality, the constitutionality of that particular law. Written by Amy Coney Barrett, she says, our cases leave little doubt that Congress's power in this field is muscular. That's the word she uses, muscular, superseding both tribal and state authority. She adds that its authority touches on subjects including like criminal defense and domestic violence, property law, she invokes, employment, trade issues, all kinds of things. She says the Constitution does not erect a firewall around family law. A great affirmation, if you will, not only upon the ICWA, this law that does indeed establish the requirement of state courts to address heritage among the Native American youth populations that appear before it, the Indian Child Welfare Act, ICWA, but also again this notion that Congress has the authority to do these kinds of things. When it acts, it means what it says and says what it means, and the challenges to this law are turned back, basically finding once again that there is no there for purposes of addressing this. Beyond that, the Supreme Court does say it does not specifically address the equal protection principles that are also raised as a part of this. And indeed, at least a couple of the Supreme Court justices say that that may yet be on the horizon. In sidestepping that equal protection argument, the justices appear to have left open the possibility of challenges on this basis of whether or not the law is racially discriminatory. Brett Kavanaugh, in particular, in a concurring opinion, he agrees with the result. The law should be upheld. But he writes that the question deserves some consideration. He says, in my view, the equal protection issue is serious. The Indian Child Welfare Act, ICWA, he added, can deny a child or an adoptive family a placement because of the child's race, even if the placement is otherwise determined to be in the child's best interests. And that's the standard typically applied in children's court for these kinds of cases. And so he goes on to say that it may be in the future that ICWA will be once again before the Supreme Court on this issue of an equal protection challenge. Of course, there are some dissenters in this case, 7-2. Justice Thomas, Justice Alito, say that Congress has overstepped in doing what it did way back in 1978. Alito writes that the Supreme Court has lost sight of those most at risk. He identifies those as children. He says the majority decides one question after another in a way that disserves the rights and interests of these children and their parents, as well as our Constitution's division of federal and state authority. A strong dissent from those two justices. Their opinion, however, not the law of the land as of this month. ICWA remains the law of this land. Again, a strong affirmation by our Supreme Court of the applicability of this important law to address not only the history of Native American, our indigenous populations, but to ensure that that heritage is not lost on future generations, and that to the extent possible that placements are made in our state courts to families of Native American heritage that can ensure that that heritage, that history, continues to be recognized and observed, and even a part of the growth and development of young people in our nation. Why is this case important? Well, again, it's a huge victory, nonetheless, notwithstanding the dissents and their statements that this is not about children. Indeed, it is about children. It's a huge affirmation for children in America, specifically Native American children. It's a huge affirmation, once again, for Native American rights. Another case we'll talk about down the road goes in the opposite direction, having to do with Navajo water rights. The Supreme Court went in an opposite direction. We'll talk about that in a future show. But this day we talk about this ICWA affirmation, significant again for the purpose and the authority of the Congress to address these issues, to once again say what it means and mean what it says, and to ensure that this law is enforced in our state courts, including right here in Wisconsin, in perpetuity. An affirmation, once again, all about children and Native American children in particular. Let's talk about another case. It also involves human beings, which is, again, the theme of these four cases. Again, another reason to celebrate what the Supreme Court has done. This one in the area of Medicaid and Medicare. We've talked about this case in the past. It involves a Medicaid and Medicare, comes out of the Seventh Circuit. It's one of two cases the Supreme Court has been reviewing when it comes to the Seventh Circuit and its decision. fellow named Georgi, G-O-R-G-I, Talevsky, T-A-L-E-V-S-K-I. He's suffering from dementia, and he resides in a state-operated nursing home in Marion County, Indiana. He is the person whose name is given then to this case called Talevsky. And based upon some allegations of unnecessary medication and improper transfer to some distant facilities, his family, Talevsky's family, sues for damages. This is basically a nursing home abuse case. Sues under something called the Federal Nursing Home Reform Act. The Federal Nursing Home Reform Act, FNHRA. And the state responds to this lawsuit, again pending in Indiana, by saying not only is there not been any mistreatment of Mr. Talevsky, but also significantly advocating for a major change in the law in America. And basically says that under Medicaid, and indeed Medicare as well, patients like Mr. Talevsky and his family should have no right whatsoever to sue for these kinds of civil rights, human rights violations. That position, effectively advocating for a reversal about 50 years of precedent under what's called Section 1983 of Title 42. What does Section 1983 say? We've seen this a lot when it comes to police violence and government authority. It says every person who under color of any statute, ordinance, regulation, custom, subjects or causes to be subject any citizen of the United States or any other person the deprivation of rights, privileges, or immunities secured by the Constitution shall be liable to that party injured in an action at law. It gives a right of action, if you will, for deprivations of rights under the Constitution. That's Section 1983. So in combination with this Federal Nursing Home Reform Act, that's the basis upon which the family of Mr. Talevsky comes forward and says, we believe he's been abused, and we should be able to sue for those abusive behaviors visited upon him by the nursing home in Indiana. Again, the state responds and says not only did we not abuse Mr. Talevsky, but beyond that, the standards, this very implication of the standard, the invocation of the Medicaid principles, Medicare principles, Section 1983, those should be turned back, and the Talevsky family should have no right to sue. Again, under a long-standing predicate for these kinds of actions having to do with federal spending laws, it's always been a part of the contract, if you will, Medicaid, Medicare, that if states accept funding under those federal programs, they also need to be susceptible to these kinds of lawsuits. And what is the reason for that? It ensures integrity when the monies are given to institutions providing this kind of care. Also ensures that there's notice if indeed there are abuses of patients like Mr. Talevsky. When we come back, we're going to talk more about the implications of Talevsky and what the Supreme Court decided when it comes to this challenge to the law in the United States Supreme Court. Stay with us again for that important discussion.
Your son is playing for money in a pinchback suit and listening to some big out-of-town
We are
jazz
back
bird
this
telling them
morning.
all
Thank
about
you for
horse racing.
continuing to join me in this discussion of Supreme Court cases. Right before the break, talking about yet a fourth case this morning called Talevsky, specifically Health and Hospital Corporation of Marion County, Indiana versus Talevsky. This lawsuit seeking civil damages against a nursing home, a state-run nursing home in Indiana, based upon allegations that it engaged in actions that compromised the health and the safety and security of their father, brought by the family, Georgi Talevsky. And the state responds to that lawsuit saying not only did we not abuse Mr. Talevsky in any way, but but we've got no capacity. The state courts have got no capacity to determine whether or not these kinds of allegations happened in the first place. Why is this significantly important? Well, again, for many, many years, frankly, for a couple of decades, the United States Supreme Court has consistently said that Medicaid, Medicare embody inside them, and they do by virtue of the legislative language of these statutes, this notion that if you accept these monies as a state entity, as a healthcare provider, you've got to be able to ensure that there is integrity, there is good health care provided, and indeed, if you don't do that, you may be susceptible to these kinds of lawsuits. And again, what does it do? It ensures that health care is provided in a decent and humane way, and also alerts Medicaid and Medicare authorities to possible violations of those standards. It's got a lot of good reasons, public policy reasons, for having these lawsuits in place. And again, we have seen this, you have seen this on a regular basis, that parties will, under those circumstances where there has been abuse, file these lawsuits when indeed a nursing home has abrogated its obligation to its patient. And so the Indiana position, that is, that these lawsuits should no longer be permitted under Medicaid in particular, is a strong and dramatic break from the past. Supreme Court gets a hold of this, again, takes a look at it, again, comes out of the Seventh Circuit, plainly in Indiana, and by a 7-2 vote, again, reaffirms the tradition in this area. Writing for a 7-2 majority, Justice Ketanji Brown Jackson says that the certain unambiguous rights under the FNHRA, which again is this law that provides this opportunity to sue, that these certain unambiguous rights are enforceable through a private right of action, which is exactly what the Talevsky family is doing, permitting this petitioner's lawsuit to proceed, and the Seventh Circuit has previously ordered that as well. Significantly, Associate Justices Neil Gorsuch, Amy Coney Barrett filed concurring opinions in this. Associate Justices Sam Alito and Clarence Thomas dissent from that ruling. Nonetheless, a great affirmation again, not only for the Talevsky family, the humanity here is important, but also the future of Medicaid and even Medicare. An awful lot of people looking very closely at this Talevsky case to see what the Supreme Court would do. Why? Why is it important beyond just the specific allegations brought by the Talevsky family? A great sense that if indeed the Supreme Court were to carve out this opportunity to sue in those instances where there is indeed an allegation of abuse by a nursing home, that could open the door ultimately to undermining Medicaid completely. It's a part of the contract, as I said before, between healthcare providers and the Medicaid, and indeed Medicare programs, that you have this opportunity, you give this opportunity to healthcare recipients, to your patients, to sue when there has been an allegation of abuse. And absent that basic notion, an awful lot of people in the healthcare industry feel strongly that because that's such a key part of Medicaid and indeed Medicare as well, that absent that, this is the start of the crumbling of those very programs, which would ultimately deprive an awful lot of people in America of basic health care, as we well know. That did not happen. That did not happen by virtue of the Supreme Court's 7-2 decision, a strong affirmation, if you will, not only of the capacity to sue, but also under the law generally of this fundamental contract relationship between Medicare and Medicaid recipients and the federal government itself. The decision, again, stands as this huge affirmation, again, of the capacity of the Congress to pass this kind of legislation, and implicit, if not explicit, in it to ensure that people have the right to sue, sustaining not only the claims brought by the capacity to sue under the claims brought by the Talevsky family, but also putting to rest any concerns about the future of Medicaid. That's why this case, like the others, is so important, not just for the particular claims, but for virtue of, in connection with all of the familial and humanity aspects. It's true of all four cases we've talked about this morning. Texas versus Biden having to do with immigration, the status of immigrants in America. Allen versus Milligan, the stature of voters, particularly voters of color in America. Holland versus Brackeen, our youngest youth, Native American heritage youth. What is their future all about? And again, in connection with Talevsky, healthcare recipients in America. All of these cases, affirmations of tradition by our United States Supreme Court, affirmation of what the law has been and what it will continue to be for all of us here in America. And so, in a time when our United States Supreme Court is legitimately under fire for much of its activity, both on the bench and off, and we'll get to that, but also today a reason for, at least in these four major cases, to look at them and say, yes, these are cases that support America, that ensure the future of America, and affirms the humanity that brings us all together and makes us a part of our community. We've got a number of callers on the line, and we're delighted to have you with us this morning, offering your perspectives and observations about this and other matters. Let's take a first caller. Joe. Joe calling in from Madison. Your thoughts or comments?
Great show as always, Jim. Great detail. I wanted to respond to or offer some thoughts on the Holland case that you mentioned that had to do with Native American tribes and children. And it's just an observation. Perhaps people of Native American descent could offer more information about this. But it's my understanding, and it's an important point, I think, that there are hundreds of Native American tribes, and each one of them has their own culture and their own traditions. And I remember someone telling me one time that they had moved from northern New York, where they were with the Iroquois tribe, to Wisconsin. And
Joe, I'm going to have you hold that thought for just a minute. I've got to take a break. Please stay on the line with me and continue that thought right after this break. Stay with me, all of you, for this discussion. We are back. We're talking this morning about the Supreme Court, in particular, right before the break, chatting about this major case involving the ICWA, the Indian Child Welfare Act, Holland versus Brackeen. One of my favorite callers on the line right now, Joe. I interrupted you right before the break, making some important points about your perspectives, not only on this law, but your own experiences. And love to hear those. And we've got the time now for that full exposition. Joe, glad to have you with us this morning.
Yeah, just to reiterate, I thought it was very interesting. This particular law, it's saying that it is important, the traditions and the culture for these children. And I would just offer as some insight, pitiful though it may be, certainly other people of Native American descent could add to this discussion in a much greater way than I could. But my understanding is that the hundreds of tribes that are in the United States, each tribe has their own culture, and it's a really important point. I was mentioning that I'd spoken with a man who was from a member of the Iroquois tribe in New York. They moved to Wisconsin, and people of the Ojibwe nation were very, very welcoming. I can't remember which band it was, but of the Ojibwe nation were very welcoming. But he said in a kind of a wistful voice that it was nice that they were so welcoming to his children and his family, but they have a different creation myth than we do. And that had never occurred to me that would make of course it would make a difference. Your understanding of how the world came into being is different from tribe to tribe. And even something as simple as, not simple, but as important as drumming ceremonies in certain tribes, certainly within Wisconsin, the drumming ceremony it's sacred. It really, really matters. Where there are other tribes like the Muskogee that don't have a tradition of drumming. That is not something that they do. And it may sound, well, okay, this is just cultural, but cultural matters. That's
Absolutely.
why, that's what family is. Family passes on culture and ideas and thoughts and your basic spirit, is influenced by your family. So I just wanted to add that, and I don't know if other people might want to add other examples, but I think it's a really important point that it's not even just Native American culture, but the culture of your specific tribe.
Yes,
Thanks, Jim,
absolutely.
for the opportunity
Joe,
to speak.
appreciate the comment as always so very, very much. Important to note that in the state of Wisconsin alone, we have 11 federally recognized tribes. When I was U.S. Attorney, along with my colleague in the Western District, routine engagements, not only because of the connection to the federal government and prosecution, civil litigation on their behalf, and otherwise ensuring their safety and security, but acknowledging that there is not one homogenous tribe in America. That plainly there are many, many tribes, and they all have their great traditions, as Joe has just said, not only in drumming areas, but creation myths, all kinds of things that make the culture, the society, the history, the heritage rich and deep. And that's ultimately what ICWA is all about, ensuring that there is some sense of that connection. And as Joe just indicated, particularity with respect to the many tribes that flourish and that are a part of our national tradition. Also important to note that not only pursuant to the United States Constitution, but also treaties, that they're also sovereign nations, which is significant for an understanding their status in America and their embracing by all of us. The heritage, the history is important. Joe, thanks so much for that very important call and those observations about the implications of ICWA and this case here in Wisconsin and throughout our nation. David, calling in from Mequon, also glad to have you with us here this morning. David, your comment or thought?
Good morning. So I apologize if you talked about this earlier. I'm not sure. I just got into your show just within the last 20 minutes. But there was two cases that I was following. One, the Supreme Court ruled against the Navajo Nation in a water rights dispute.
Right.
And that's been going on for, I guess, since 1868.
Right.
With the water rights, for the water out in Arizona.
Right, the Colorado River in particular. Absolutely. Yep.
Yes. So it was interesting to note that Neil Gorsuch, who is a conservative, joined the liberal justices. But when he wrote his dissent, it was twice as long as what the majority wrote in favor of it, which I found very interesting because that's unusual to me. The other thing I just wanted to bring up, though, was the fact, and it was kind of troubling to me. It was actually more than troubling, very concerning, with the Supreme Court and the IRS. And they ruled 9-0, where the IRS can attain bank records without notifying third parties and what have you. And I understand that it was a case of somebody that was underpaying the IRS, and so they looked into other individuals that may have had an association with that individual. And so essentially they don't have to, let's say hypothetically, let's say someone in your family was doing something, maybe a relative like a cousin of yours was doing something that was not on the up and up. They could say, you know what, we're going to look into your family's bank account without making you aware of it. And I think that that's a problem. I think that gives the IRS way too much latitude as far as probing into your privacy and things without notifying, what the heck is going on. Right. So I'm not sure where you fall with that, but
sure.
Anyways.
Right. No, David, appreciate that. And yes, 60 cases altogether by the United States Supreme Court. There are 10 yet to go. Those two that you've identified are among those. At some point, probably in the month of July or so, we're going to chat about both of those, including the IRS case, getting a more in-depth analysis of the issues you identified. The case involving the Navajo tribe, again, Colorado River, also a major case. I'm going to chat about that probably in a future show as well. Significant not only for the Native American tribes, but also the relationship between the federal government and this affirmation in that particular case that the United States government does not have to engage in this further analysis about the amount of water, and had to do with the particular withdrawals, if you will, from the Colorado River. So both of those very important, and we'll talk about those down the road. Also significant, packed into that, David, your comment about Neil Gorsuch. He has consistently, he comes from the 10th Circuit, right, which is a circuit kind of in the Great Plains, the Great Midwest, and beyond. In a case called McGirt a number of years ago, wrote that, basically finding that most of the state of Oklahoma is a Native American Indian reservation. Has followed that up in dissent in another case. Has always been a very, very strong advocate for our nation's population. So as to those cases, again, important to note that again, he is not an ideologue when it comes to those issues, and that we've got justices who do in fact look at the merits of cases, and they're animated not only by the law but also about their own experiences. So great comments on both of those. And David, I promise you and others we're going to chat about those in the future. As I indicated, the Supreme Court is not yet done. Next week, it's going to be convening on at least 2 days, probably Tuesday and Thursday. At least 10 more cases to be decided. I'll chat about what those are all about in just a moment or so. But David, appreciate your observations about the Supreme Court. And what a wonderful thing, too, affirming that we've got the capacity in this country to oppose and to be in opposition to the things the Supreme Court does. That's what it's all about. So appreciate not only, David, your comment on this radio program, but the capacity to look at a decision and say, you know what, I'm in disagreement with that. And we've got to continue to be a part of that nation, that effort that ensures that everybody's got a voice and that our constituent voices are heard even by a Supreme Court that has lifetime tenure. So, David, thanks so much for that comment as well. And call back again down the road with more observations about those kinds of things. Let me also then move on to another issue related to the United States Supreme Court percolating up again just this past week, and certainly in recent weeks. We've talked about this in the past right here on this broadcast, and that is ethics. New revelations about a United States Supreme Court justice's undisclosed free trip to Alaska have apparently once again prompted not only the nation's attention but also congressional attention to whether or not there should be imposed upon the United States Supreme Court a set of rules and regulations, some ethics principles by which all the other appeals court judges, trial court judges in the federal system abide. What happened this past week? Well, we know this past week that ProPublica, this reporting group that previously disclosed an awful lot of concerns about Justice Clarence Thomas and his engagements with, his relationship with this fellow named Harlan Crow, the vacations he has taken, the fact that his grandnephew, a young man he has been raising as his son, also getting tuition paid. Clarence Thomas's own spouse, Jenny Thomas, also unrelated to Harlan Crow, doing an awful lot of advocacy when it comes to January 6th and the 2020 election, making decisions, that is, Clarence Thomas, in matters that his wife herself is much involved in. All of those things, a part of the now recent history, raising questions about whether or not the Supreme Court should have this ethics standard, a set of standards by which it should be guided in recusing particular justices from deciding cases in which they've got particular interests, financial interests, familial interests, friendship interests, all those kinds of things. We know that the Congress has recently, through a fellow named Dick Durbin, who is the chair of the Senate Judiciary Committee, invited the Supreme Court Justice, the Chief Justice, John Roberts, to appear before the committee and talk about these things, talk about the extent to which rules and regulations need to be imposed upon the Supreme Court. Chief Justice Thomas respectfully declined to do so, issued, in fact, a set of principles and guidelines signed by all members of the Supreme Court, committing to the highest levels of propriety when it comes to ethics and decision-making. Plainly not satisfactory. And in the wake of all of that, now this past week, some additional information coming out, as I indicated, about Justice Sam Alito. In particular, statements, again, reporting from ProPublica that Sam Alito took a free vacation to an Alaska fishing village way back in 2008. That was based upon the financial generosity of a hedge fund billionaire, his name is Paul Singer, and a mortgage company entrepreneur named Robin Arkley. Singer flew Alito to this fishing lodge on a private jet, and Arkley, who owned the lodge, provided the accommodations. Alito later ruled for Singer's hedge fund in a case that helped the fund recover about $2.4 billion. Again, a case pending before the Supreme Court in which this good friend, apparently, of the justice was much involved. Interestingly, Justice Alito, even before the ProPublica report came out this past week, issued in the Wall Street Journal a very lengthy and very detailed response to what was going to be coming out from ProPublica. I encourage all of our listeners to read not only the journalism report from ProPublica on this particular issue, but also Justice Alito's response to that. Both of them are informative, and you can make up your own mind on whether or not this is another problem facing the Supreme Court. It almost certainly is. Justice Alito said that while he certainly confirms the vacation and the trip that was taken, said a couple of things in response to the ProPublica report. He said, number one, that he was not required to recuse himself under the particular facts and circumstances of this case, and also that the cases did not require him to disclose the travel. He said they had spoken to Singer only a handful of times, including 2 occasions when Singer had introduced him before some speeches. And in particular, Alito says this. He says, it was and is my judgment that these facts, the cases involving his going on this vacation, would not cause a reasonable and unbiased person to doubt my ability to decide the matters in question impartially. He added that he did not know of Singer's connection to the cases before the court, including in particular this one in which the court ruled 7-1 in favor of Singer's position, his businesses that yielded a huge amount of money, that case involving the Republic of Argentina. There was a fair amount of notoriety at the time in the New York Times, other places, focusing upon the fact that the Supreme Court had handed billionaire Paul Singer this victory over Argentina. So some fairly public notice suggesting that some of the defenses offered by Justice Alito to this situation, which he sets forth in the Wall Street Journal, may not in fact be as strong as you might otherwise think. All of this, however this plays out, however you look at this, nonetheless, a reason for congressional response. Right after the break, we're going to talk about what that congressional response is going to be and what Dick Durbin has waited long enough for, according to him. Stay with us for that discussion, all about the United States Supreme Court.
To stay, 'cause you can't stop the beat. There's a secret verse on the side, a little woman likes to shake it when the day is through. So we will shake and shimmy and have some fun. But today, you can't stop the motion of the ocean or the rhythm of blood. You can try to stop the paradise with the rhythm of the
Is this the little girl I carried?
And we are back in this final segment of our broadcast this morning, Morning Cannolis. We're talking about all things Supreme Court right before the break, talking about this latest great concern among all Americans, and I would suspect even inside the Supreme Court, about ethics, and in particular this latest revelation that Associate Justice Sam Alito took this trip, arguably in the value of about $100,000 to Alaska a number of years ago, did not disclose it. And the person who provided that trip and even the lodging, the trip in particular provided by an individual, Paul Singer, who had cases pending before the Supreme Court involving one that Associate Justice Sam Alito voted on, a case that was resolved in favor of Paul Singer. A vote was 7-1, so the vote in the end probably would have been in the direction of Singer, even without Justice Alito's involvement. But he failed to recuse himself at that point, and now is defending himself, not only on the basis that his connections with Paul Singer were remote, but that under the rules and regulations such as they exist right now, not obliged to report this, no conflict of interest. Now, all of this, again, in the wake of the matters involving the Supreme Court generally and Justice Clarence Thomas, now Sam Alito, and perhaps others on the court, prompting renewed focus by the United States Senate in particular. The Senate Judiciary Chair, Dick Durbin, has in the past said that the Supreme Court is in the middle of an ethics crisis of its own making. And while he was the recipient of this ethics principles and practices document signed by all members of the Supreme Court in which they committed to following the highest levels of propriety, that plainly has not satisfied Dick Durbin. Nor has it satisfied another senator. His name is Sheldon Whitehouse. He is a Democrat from Rhode Island. They have spent months looking at this issue involving the United States Supreme Court, conflicts of interest, recusals, and ethics issues generally, and have recommended the Supreme Court impose upon itself perhaps the same kind of thing that all of the federal judges around the country now have to abide by. That has not happened. And so in the wake of all of that, what has happened this past week, including the revelation about the Associate Justice Sam Alito, is that the Supreme Court now is going to be the focus of some legislation coming out of the Senate Judiciary Committee. Dick Durbin has promised that after the Independence Day holiday, there will be a vote on a piece of legislation called the Supreme Court Ethics, Refusal, and Transparency Act. It was introduced by Sheldon Whitehouse way back in February, and the bill would require the Supreme Court to adopt a code of conduct within 180 days of its passage. Again, this is pending in the Senate. Dick Durbin saying there will be a vote on this legislation after the 4th of July. According to the basic structures of this bill, would require the Supreme Court to adopt rules requiring disclosure for gifts for justices and their law clerks. They're at least as rigorous as the House of Representatives and the Senate disclosure rules. In other words, good for Congress, good for the Supreme Court as well. Would require greater disclosure of amicus curiae funding, which is how it is that monies are supporting the filings of amicus briefs to the Supreme Court, friend of the court briefs, requiring parties and those who submit those briefs to disclose travel, gifts, and reimbursements to justices. Would ensure that requests for recusal are reviewed by a panel of randomly selected judges or the rest of the Supreme Court. In other words, getting at this recusal issue beyond just a particular justice, and would require written explanations for those recusal decisions. That's one of a couple of pieces of legislation pending right now in front of the Congress. There's also House legislation. Unlikely that that will get a vote anytime soon, but coming up again for a vote before the United States Senate right after the Independence Day holiday, a sign playing that the United States Congress continues to be focused on this and that it does not seem to go away, especially in the midst of these continuing reports about issues involving ethics and recusals. It is a reason for all of us to be concerned. There are remedies to this, not just legislative. The Supreme Court, as I've said on many occasions in the past, should itself adopt a code of ethics and regulations, should impose that upon itself. It could track what Sheldon Whitehouse and others have proposed, or could simply adopt the rules and regulations through the judicial conference that all of the other judges, the appeals court judges, the trial court judges abide by to this day, an issue that plainly is not going away anytime soon. All of that happening as the Supreme Court again next week is going to be deciding some of these major cases still on its docket, at least 10 more cases yet to be decided. I'm going to chat more about those in just a minute or so, but we've got another caller on the line, Gene. Gene, love to have you with us this morning. Appreciate your comment or question as well.
Thank you for your wonderful show. I appreciate it every weekend. I learn things, and you're just outstanding instructor. Their resistance and their reactions to the people's concerns regarding their judgments, monies that have come in, the way that amicus briefs are put in, and all of the things, to me, I do not have any confidence in their decisions, period, until they take responsibility. And I go on the record today.
Very good, right?
That they need to address this issue as a public person. I do not trust their judgments. I do not trust their integrity or their anything that they have to say right now till they do this. This is so important. Thank you so much for taking my call, and you have a great weekend. And
absolutely,
keep up the great
Gene.
work.
Always good to hear from you. Thank you for that observation. I suspect you articulate the views of many Americans out there. And the concern is, Gene, you and I have talked before on this broadcast, is yes, it's about recusals, it's about ethics, but it's also about something even beyond that, right? We have talked today about these major cases pending before the Supreme Court. Today is the one-year history of Dobbs, all those kinds of things. When you and others legitimately look at the Supreme Court and say, I don't trust your capacity to make these calls about ethics, it also tends to undermine your trust and your confidence in the substance of those other issues, right? Those other things that are yet to be decided, and that's when the integrity of the very institution of the court gets called into question. That's why I could not agree with you more, Gene, that this is a huge, important, significant issue. It needs to be resolved, if not by the Supreme Court, then by the United States Congress. It has to happen soon as these important decisions continue. We have yet to hear in this next week, probably again on Tuesday and Wednesday, more of these major cases. What are those cases going to be about? Whether or not you can determine admissions to colleges and universities based in part upon race, a question about the extent to which state courts are involved in our elections, the student loan forgiveness program by the President of the United States of America, whether or not our LGBT communities have a right to freedom from discrimination in commerce and religious accommodations as well. All of that and more coming up in this next week, Tuesday and Thursday. And you can be certain that we're going to be talking about all of those cases and more things related to our Supreme Court next week as well. Join us for that discussion. Thank you for being with us this Saturday, and have a great week, everybody. Take care.